myself for 5 minutes. Mr. Alcorn, your written testimony says that when the union was certified at your Trader Joe's store, you and other members of the bargaining unit had trouble getting information about your rights and about collective bargaining negotiations. What could be done to make sure people in unionized workplaces like Trader Joe's know their rights?
Thank you. I think workers should be informed of their rights when an organizing campaign is going on. I think they should have access to the information about that union, all the disclosures about the Constitution, the bylaws, any previous collective bargaining agreements. In my case, we had no information for the union that we were voting for and didn't know how to get more information. So essentially, we were signing a blank check when we were signing that union authorization card. So I think more disclosure, more transparency is what workers deserve.
Mr. McDonald, as you point out in your written testimony, a labor union has a duty of fair representation to its members when it bargains with the employer, but it has no such duty when it engages in politics. What are your concerns that the duty of fair representation does not apply when the union engages in politics?
Well, the chairman's correct that the law...
Mike, sir.
Thank you. You're correct, Mr. Chairman. The law does guarantee that when a union is representing members at the bargaining table, the union must fairly represent the workers, all workers that are represented. And that principle isn't actually in the statute, per se. It has been inferred by courts from the duty or the right of exclusive representation from a union when it bargains collectively. Under the duty of exclusive representation, workers cannot bargain for themselves when there is a union certified in their workplace. The union bargains on behalf of everyone. That duty, however, has not been extended to all the other activities that a union undertakes. Again, you pointed to the union's political activities. There is today no legal duty on behalf of a union to engage with its members, to see whether its members agree with its political views, to make sure that its endorsements or its political statements reflect its members, even though those statements are made ostensibly on behalf of the union. I mean, we've heard some statements today that the union is the workers, the union is standing in their shoes. There frankly is no legal protection in that aspect, and that's an area of consideration for the committee.
In your opinion, how can we ensure that unions are representing their members in the political arena?
There are several options available to the committee. One would be, and it has been proposed, this is not my idea, it's been proposed multiple times in multiple avenues, to actually statutorily guarantee the duty of fair representation. And were the duty of fair representation to be statutorily guaranteed, there's no principle that would necessarily have to limit it to the bargaining table. Again, that duty has been inferred by the union's exclusive right at the bargaining table, but were it a statutory right, the committee could consider other aspects of representation, all aspects of representation. So that is an area of exploration and potential legislation for this committee.
Thank you. Mr. McGrath, the Labor Management Reporting and Disclosure Act requires union members who want to vindicate their rights under the act to go through the union's internal hearing procedures for up to 4 months before they can bring a case in court. What is your opinion of this exhaustive requirement?
Well, I think that from a practitioner's point of view, there's two things that would concern me there. What we've heard, especially from our clients as well, is that the first is to go through that 4-month process, going through it alone, and in the situation that we're considering here, which would be the employees perhaps adverse to the union official or to the union, they have to run through a 4-month process that's really run by those who have a self-interest in not being held accountable. And so at the end of 4 months, the second problem could be that if they do choose to go through that and they do endure kind of the testimony and the hearings and the decisions that could happen, once they finally do get to go to court, instead of starting with a clean slate, they're followed by the baggage that could come through the 4-month hearing process or the exhaustion process that they would have. So it's very daunting for them to choose to do that on their own, and then when it follows them into court, they're not actually getting a fair shake there either.
And how would this help union members?
Well, it would help in 2 ways, just kind of follow up on my points. Number one, a person wouldn't be weeded out early because they are concerned about going through the 4-month process that's weighted against them. And so they could just go directly to court. And then the second benefit would be when people go directly to court, there's no past history that the unions then could try to bring into court and say, hey, look, in the last 4 months, they said this, or this decision happened in our internal process.
Thank you. I'm out of time. I yield back, and